The Honourable Phil Goff.
Mr Speaker, this debate's an unusual debate in the sense that it's considering two bills together, cognate bills, fairly new term even for an old-timer, but it's because the two bills are dealing with very similar matters. Both bills are intended to protect the community against people who have completed a finite term in jail but are still considered as being at extreme risk of reoffending. And I listen closely to my two colleagues in the Green Party, and I always respect where they're coming from. They take a principled stand, but it's not a stand that I agree with, Mr Speaker, and I'll touch briefly on that. Yes, human rights are a universal rights that they apply to everybody, but we are dealing with people that I had to deal with when I was Minister of Justice that I knew were totally incapable of controlling their urge to offend and to offend seriously. And the choice that I had to make at the time, and therefore I understand the choice that the current Minister is making at the time, was if I let that person out because they've completed their finite sentence, they will offend, and their breach of other people's human rights, and particularly children, will be serious and fundamental. I'm talking about people, a particular individual, the individual why the Parole Extended Supervision Orders Bill has come before the House. I brought the bill in because of him and a group of people like him. His name is Lloyd McIntosh. It's in the public arena. He has an IQ probably of 80 or 90. He is incapable of controlling his urges. He's not evil, he just cannot control his urges. And he was convicted of raping a 2-year-old child with awful consequences. The child never died. Now, Lloyd McIntosh and his mother both want to maintain a regime of this nature. So I'm very conscious of the fact that when you serve your finite term, generally you've done the crime, you've done the time, and you can start again. But we're talking about a particular group of people who are extraordinary, and they're extraordinary because they are at imminent risk of reoffending seriously. So what the Parole Extended Supervision Orders Bill does is extend the legislation that I brought in 2002. And it does that by saying that when you've reached the end of your 10-year term, you can be considered and you can have imposed on you a further term of close supervision. The interesting thing about the extended supervision orders is that the people are still in the community. So we're trying to minimise the degree of control or limitation on their freedoms on them while protecting the freedom of others to be protected. And this is a bill that has applied to about 332 offenders and still applies to about 251. What will it do? According to the departmental statement, it will probably affect 25 to 30 high-risk sex offenders against children a year. 25 to 30, that's a significant number. If we did nothing about that, the number of victims would be multiples of that number. It also, as well as extending the term beyond 10 years, it extends it to two other categories of offenders, both with high risks of offending. One is sexual offenders against adults. That will affect a much smaller number of people a year, 4 to 9. And also a third category, violent offenders, extremely high levels of risk of reoffending. That will affect only 1 or 2 over a 5-year period. So significant numbers, particularly against children, and smaller numbers in the other categories. Interestingly, this is a bill, and regrettably this is a bill that does breach the Bill of Rights. It breached it in 2002 and it continues to breach it, and we have the Attorney General's comment on it. I would very much like to have avoided doing that. I do not ever lightly support a breach of the Bill of Rights. And I raised it at the Select Committee, and we considered whether we could do what the Public Safety Public Protection Orders Bill does, which doesn't breach the Bill of Rights, and that is make it a civil regime. The Extended Supervision Orders is a criminal regime because people come before the Parole Board. And what we found out is that you could do that, but you'd be duplicating the regime that was already in place, and there'll be certain risks in doing that. The impact on the offenders would be exactly the same, but we would actually remove it from breaching, in principle, the Bill of Rights. And I thought, well, I'd love not to do that, but actually, should we go to this expense and to this risk if the impact on the individuals is exactly the same? And in the end, I came to the conclusion that probably that was not warranted, particularly because the Ministry of Justice was unable to work through the alternative regime in the time frame before this bill would come into effect, which is designed to deal with the situation of Lloyd McIntosh and others in the same position. The Public Safety, Public Protection Orders Bill, I wasn't on that select committee, but I did speak on the introduction, and I have read it carefully. And it allows, again, for people who have completed their finite sentence to be detained, this time actually in a secure detention facility. So it's not out in the community like extended supervision orders. It is in a place where there are walls and fences, and they are unable or unlikely to escape. This applies to a much smaller number of offenders, about 5 to 12 over a 10-year period. It's a tiny number, but the consequences would be huge if those people were let out into the community and we were unable to prevent them from reoffending. I looked closely at what the characteristics were in order to have a person put in this position. First of all, the judgment is made, it's not a political judgment, it's made by a High Court judge. And there are 4 characteristics that a person has to have. They must have an intense drive or urge to commit a particular type of offending. Much of that would be sexual offending against children. They must have limited self-regulatory capacity. They must have an absence of understanding or concern for the impact of their offending on their victims. And they must have poor interpersonal relationships or social isolation. So the Act is quite specific. The judge will make the decision, and the judge will make the decision on the basis of people who have the professional, medical or psychological skills and have had the opportunity to make that judgment about the person that has been in prison. Now, of course, there are other ways that you could do this. One is, of course, there are many offences, or there are some offences, I should say, where there is a life sentence. For murder, you always get a life sentence, and that can be with a minimum parole period or not, generally at least 10 years. And that makes it easy to deal with those people, because even when you let them out on parole, they are on parole for life and they can be recalled at any time. We also considered at the time a much wider use of preventive detention. Preventive detention means that you can lock a person up indefinitely. It's an indeterminate sentence. And in some ways that would avoid entirely the Bill of Rights issue, because if you give them that as a sentence of the judge, you are never in breach of the Bill of Rights. That is a sentence made, and the person can be locked up for life, literally, and if they are let out, they can be recalled at any time, and that happens. But, you know, in some ways it would be a more severe regime to have a much wider use of preventive detention than what we're doing with these 2 pieces of legislation. So, Mr. Speaker, I support, and Labor supports, these 2 pieces of legislation. We have considered them carefully. We are not doing this for any knee-jerk populist purpose. We are doing it for the fundamental responsibility that we have in this House, that responsibility being, where we can, to protect people, particularly vulnerable people like children, against offending that is classified as being either almost inevitable or there being an extreme risk on the part of that offender to go on offending and to cause and inflict appalling harm on other people. I think we've got the balance right, and the Labor Party is supporting the second reading of these bills.